So let's talk about the Amicus Brief. Why was this filed and what is the goal?
Mm-hmm. So the Amicus Brief, I file on behalf of the Chamber, really to speak on behalf of the industry and the Chamber's members on being a friend of the court and ensuring the court is aware of what legal precedent exists and what legal precedent doesn't exist as applied to blockchain and digital assets generally and offerings in this area. The Chamber's interest here is to ensure the proper law is considered by the court and the court is aware of the impact their decision, especially on the legal side, will have on the industry as a whole. So the Chamber, this was a follow-on to a brief that I had filed in the SEC versus Telegram case on behalf of the Chamber. And really the premise behind it is making the court aware of what the Howey test is, the Howey test and what an investment contract is. I think many in the market already know, but that the Howey test is really about the investment contract. And it's separate and distinct from the subject of that investment contract. Assets are offered pursuant to investment contracts and need to comply with the securities laws. But what the subject of that investment contract is not itself a security. What that asset represents, the law is currently still unclear on what the subject of investment contract itself represents, but also the brief cites two examples of other investment contracts that had commodities that were subject to investment contract. There were cases about beavers. Oranges are well known. Oranges can be eaten. Beavers can be used for their pelts. Condos can be lived in. So assets could be sold. Some are commodities. There could be assets that are not commodities sold pursuant to investment contracts. But the court needs to distinguish and properly think about what the subject of investment contract is when considering what law applies to an investment contract in the case. It also, the brief goes further in that it talks about the fact that there is no law on a digital asset that was previously sold pursuant to investment contract and later sold in another transaction, whether that's a technology transaction, commercial transaction, or another securities transaction. There's no legal precedent as to the secondary trading. And the court may not even the decision may not even go to whether or not it needs to think about secondary trading, but it was important for the Chamber's members to highlight that the fact that there is no legal precedent on that secondary trading component, and also highlights a number of regulatory and legislative initiatives that go to that question that the court could draw from to the extent it does need to set a precedent on secondary trading.